Welcome to the Legal Hour with Bailey and Gallion. We're here today at the Legal Cafe at the corner of Main and First Street in Fort Worth, just across from the courthouse. It's 100 degrees outside, so I'm happily indoors today. And I'm here today with Teresa Sanchez. Teresa is the head of the Family Law Department at Bailey and Gallion, covering all of our 13, 14 offices. And we're here today to talk about family law. It's not like it looks on TV. What I find about family law is that the emotions run pretty deep, but I think everyone really needs an attorney because the outcomes are usually fairly predictable. Don't you find that, Teresa?
I can see that.
I think it's one of those things where once we figure out what the facts are, the judge has somewhat limited discretion, and certain things in family law are math equations, all right? And so knowing what those equations are can be really, really helpful. Teresa, if someone is looking to find and choose a family law attorney, what kind of advice would you give them?
I would tell them to meet with the attorney in person. I would advise against trying to do it over the phone.
Mm-hmm.
I think they need to set eye to eye and see the person that they're wanting to hire to take care of their legal matter. I think that's important.
Mm-hmm.
I think they should kind of use what I guess I refer to as the Reader's Digest rule. If it feels right with that person, then it probably is. So instead of trying to fit square pegs into round holes, probably go with your first instincts. But I think eye-to-eye contact and getting away from the convenience of this telephone is probably the best advice I would give someone, eye-to-eye contact.
I think it is hard to read people through Zoom and things like that. What are you looking for? What would you suggest folks look for in the way of experience?
Well, I think it depends on what type of matter that they have. If they have a divorce, let's say, and they've been married less than a year, they don't have any real property, and they don't have any children, then I think they could go with a lawyer that's been out and practicing 5, 6, 7 years. I think easily that could happen, especially in family law. And our counties here in North Texas are somewhat predictable, so you can probably get a good idea of what's going to happen. If you've got a long-term marriage where there's multiple real properties, you may have a business, you may still have one child under the 18 or still in high school, and this has been long-term, then I think they need someone that has plenty of experience, and they may even want to consider someone that's board certified in family law.
I think folks have the same difficulty choosing an attorney that they have choosing a doctor. If you're not in the field, it's really hard to know who's good and who's not. And unless you have a buddy who's recently done this, you're almost left to trying to look at their credentials. But if you'll ask around, and if you'll call the bar associations, many times they'll give you a lead.
Yes.
On some folks who handle these types of cases. And remember, like Teresa said, family law is an incredibly broad area. We handle divorces and adoptions and terminations and child support and just a wide range of issues. And so do your homework, I think, and ask around. And if an attorney makes you feel uncomfortable or you just don't feel it, then keep looking. One of the difficulties that I've encountered occasionally are clients who are not particularly candid with their attorneys. They're a little cagey. I've actually asked people, tell me about this, and they'll look me square in the eye and say, what do you want to hear? I want to hear the truth. It's privileged, okay? I can't tell anyone else, but I sure hate to learn about the skeleton in the closet from the witness stand. when I can do nothing about it and I can't give them any good advice about it. Have you encountered folks who just for whatever reason, maybe they've watched too much TV, but they think that this is all a chess game and I'm only going to tell the attorney what he wants to hear?
Absolutely, and that's one of the biggest downfalls that anybody can make in a legal matter of any kind, is not telling your lawyer exactly what happened, giving them the documents, giving them the information that they need. The worst situation that can possibly happen is for the client to say, well, I've been screening the information I give you because I just didn't really think it was necessary. Then what did you hire us for? If you're going to run the case and you're going to decide what's relevant and what needs to be there and how we're going to handle it, what did you hire us for? Because it's one of the worst things that could possibly happen is when you're sitting in court and you're hearing this stuff for the first time and you go out in the hallway and you say, so, and the client answers, I didn't think it was important. I didn't ask you if it was important. I ask you to give me the information that we need.
It's almost like fibbing to your doctor. So how many packs of cigarettes do you smoke a day? How many drinks do you have a week? It's actually important information, but too many times people won't fess up to it because they're embarrassed or they're too private.
I agree with you. I think probably if we asked doctors, the answer to how many drinks do you have in a week would be 2.
Yeah, everybody says 2.
Everybody's 2.
Yeah, it's the same thing to the cop if you get pulled over. They always had 2.
Oh, they had 2.
Family law, we've talked a little bit about the fact that frequently, if Teresa and I know what the facts are, we can give you a pretty good idea of the limits that the court has in fashioning a form of relief. And sometimes things just really won't happen. And I find that it's really important for the clients to have reasonable expectations. All right. Some people, again, it's too many movie plots. All right. Once the judge hears that he wore white after Labor Day, well, he's not going to want the children exposed to that kind of fashion mistake. He's going to throw that law book out the window and just give me everything I want. How often have you seen that happen?
No times.
No times, okay? The court is there, honestly, as a last-ditch effort to avoid killings, okay?
I agree with that 100%. I do.
We invented the court system so that people wouldn't end the dispute with a sword or a gun. And the poor judge has a lot of cases to deal with, and he is never, or she, going to know the intricacies of what's in the best interest of your child, what your financial arrangements are, what your tax considerations are, as well as the parties do. So in a perfect world, the parties make all the important decisions because they're the 2 smartest people in the room. But when you go to court, and sometimes you have to, the judge is having to make the best decisions they can make on much more limited information than the parties have.
Yes, and then to dovetail off of that, the judge is never going to know all the information on the folks' property. Mm-hmm. And having someone that you've met for an hour and a half on the witness stand decide who's going to have the house, who's going to pay the debt, where the cars are going, what's going to happen to all this property, is probably one of the least attractive ideas about the legal system. The more that these parties, and I agree with you, sometimes you just have to go to court. Mm-hmm. But the more the parties can sit down and divvy this stuff up themselves and figure it out for their children, the better off they will be in the long run. There's no good outcome on having a third parent flopped down in the middle of an already fractured scenario.
And the judges uniformly would rather not parent your children. They would much rather leave you to parent your own children. Now, as we discussed, there are some times when you just have to go to trial. Sometimes you have a circumstance where, due to mental illness, or somebody has a drinking problem, or there's violence in the marriage, there's a lot of reasons why reasonable communication between the parties might not be very productive, okay? And those are generally the cases that I see go to trial. I would estimate over 95% of the cases actually do settle.
Oh, absolutely. I agree with you 100%. And I agree with what you say. Most of the cases that we're going to trial on, there's a real issue.
Mm-hmm.
There's a real issue, and that's unfortunate. It's unfortunate for the children, but in the long run, having someone on the bench who can be that third person in a drug situation, alcohol situation, domestic violence, whatever it may be, it isn't a great thing, but it's not necessarily a bad thing. He or she can become a gatekeeper.
Absolutely, absolutely. And it points out an important issue in family law. The hardest work that you're going to do as a client is in the early stages of your case.
Agreed.
We'll talk in a minute about the importance of preparing for temporary orders hearings. But what happens in a lot of cases is we start gathering facts. We put together some temporary orders that usually people can agree with. And then things tend to calm down for a minute and people start thinking and settling. There's a lot of times, there's a 60-day minimum cooling off period to get a divorce in Texas. And part of the reason, I think, behind what the legislature did there was saying there's a lot of folks who get served with divorce papers and they're shocked. They didn't know that there was a problem. Their spouse has been thinking about the pros and cons and working through it, and finally comes to the decision, I'm going to end this marriage. And they serve their spouse, who is shocked, horrified. Wait a minute, baby, we can talk, okay? And it takes a little bit of recovery time before they start thinking straight, don't you think?
No, I absolutely think, because it's normally in those types of situations, it's been a long time coming on both sides.
Mm-hmm.
Just one person took the step first and it caught the other by surprise. But normally those are kind of a long time coming cases.
Mm-hmm. And just to be fair, I can count on my fingers. I've been doing this for 37 years, and I can count on my fingers the number of cases I've seen where Mother Teresa hooked up with Satan. Okay, and they had children. Okay, generally speaking, the relationship has been dysfunctional for a while on both sides, wouldn't
Correct.
you say?
I agree 100%.
But on the first visit, it's always that other son of a gun who's the problem. So most of the cases, most of the courts in this area will frequently require us to go to mediation before they'll give us a trial date.
Yes.
Why do you think mediation is so important, and how do you prepare for it?
I think mediation is important to the parties. It gives them a chance to sit down with somebody that doesn't have, quote, a dog in the fight, and let that person go back and forth between the two rooms or the two tables, whatever the situation may be, without the parties being in the same room, so they can try to fashion up an agreement. I think that in mediation, I'm like you, I've been doing this coming up on 35 years. I could probably count on one hand the number of mediations that have failed. Because people, once they get there, they start hearing and seeing the pros and cons, because you can talk very freely with the client, with the mediator, and then they can go back and forth. It gets them to a result quicker, and a result they can usually live with quicker. Which leads to, on most cases that are mediated, you don't see such a high modification rate.
That's true. That's true. I tell folks in mediation frequently that about the best thing that can happen to us today is for your spouse to leave here thinking they won on something that was important to them, because you're not driving a wedge between them, because folks still have to co-parent for the rest of the child's life. Forget age 18. There are marriages and grandbabies and all of this kind of thing.
Yep.
And if the two of you can cooperate for the best interest of the children, who you love more than anything, then you're making some headway there. The other thing that I find that mediation can be very educational to clients. Now, I try, and I know you do too, to have a sit down with the clients and let them know what to expect and how mediation works and that sort of thing. But there's a rule that we have to look at in family law. I'll refer to them as presumptions. Okay, when we were discussing that the court doesn't have just unlimited discretion, it's because we have certain presumptions under the law that guide the judges. So, for example, we presume it's better not to split up siblings and say, we're going to send the girl to live with mama and the boy to live with daddy. Okay, we think siblings benefit by being together. We generally think it's a good idea not to have one parent move the kids 1,000 miles away and impede access to the other parent. But there's a lot of presumptions that we're working with.
I agree with you, because when the idea that I think one of the biggest things that walks through the door, if it's in a suit in which the parties weren't married, is the idea that, well, we have an agreement on child support. And that's great, as long as both sides really agree to that and we can really put that in the order, that's perfect. But here's what we can't do. If someone has the Attorney General involved because there's some sort of state assistance for health insurance for these children, the presumption is somebody's going to be paying the state back for that health insurance premium. It's called cash medical. The other presumption is somebody's paying child support. So unless we truly have an agreement on all these issues, all those things are really happening.
And parents might agree to a certain child support amount, but I find the state of Texas is somewhat more reluctant to say, yeah, we'll just chip in the Medicaid and don't worry about it, okay? A lot of folks will come in and say, they put me on child support. No, they didn't. The child's on Medicaid. And so that's a guarantee that it's going to happen. All mama did was collect or she signed the forms to get the Medicaid so the child would have health insurance.
And then that triggers the Attorney General to file a suit. And that's probably one of the most misconceptions, that she did this.
Oh, yeah.
Bet she didn't. I bet it's because she was asking for the food stamps or the Medicaid, the chips, whatever the case may be. That triggered the Attorney General.
I've had a lot of folks come in and use very cliche arguments, okay? If you're a judge and you're considering a family law dispute, judges are no different than anyone else, and they do tend to lump folks together in groups a little bit. When you have the mother, for example, saying, I'm the mother, I need to be in charge, he's a no good, scurrilous scumbag, and I said, but you picked him, okay?
You're more polite than I am.
He should have a role in the kids' lives, right? And by the same token, you have the fathers who come in and say, oh, she's a terrible, horrible, no good, very bad mom, I need custody. She's ruining that child. Well, the child is 12 years old, has lived its entire life with mom, but now that someone wants child support, she's a no good, terrible, very bad, awful mom. And as you can guess, the courts kind of question the credibility of both of those sets of extreme parents who are in there to hit a home run. And they're not really thinking as clearly as they could about the best interest of the kiddos.
I agree with you 100%.
Okay. Some of the presumptions we also have deal with visitation. And Texas has, I think, some of the most liberal access schedules in the country.
No, I agree with you on that. We see a lot of people that want to modify an out-of-state decree or an out-of-state order. And they bring them in, and you look at some of this stuff that these other states are doing, and you're thinking, your courts must be jammed up with 10,000 cases a day if this is the way you all handle the visitation. I think that we are at the forefront in Texas. I think Texas should congratulate itself on the way that we handle possession and access. We're incredibly detailed. There isn't any left, there isn't any right, unless the parents want to make it lefts or rights. But for the most part, I think we're at the forefront. I'm trying to get the children equal access, to the moms and the dads if they can do so safely. And that's always the key, get it safely.
Right. And the interesting thing to me about our visitation is it is pretty close to a 50-50 standard if the parties are living relatively close to each other.
Agreed.
And like you said, I see some states where the visiting parent may only get 3 days a month or something like that, and I see really, really short decrees. Just our visitation schedule in Texas runs about 14 typed pages, and it's very specific. But one thing people forget about that is the visitation guidelines that the courts are using are actually intended to be a fallback position. The first paragraph always says what?
It always says, subject to the agreement of the parents. And if the parents can't agree, this is what we're going to order.
Right.
And if people did agree to something different, go right ahead and do that. Having said that, in all fairness, you can set presumptions when you go too far out
Sure.
of what the possession order is to where there could be an issue in the future. But for the most part, most people try to stay out of court. After you've had one taste of it, we don't like to have a lot of repeat people.
Well, you hate to spend all the kids' college money on attorneys.
Absolutely.
Okay.
That's
But
attorney's fees.
you think about how life deals you funny cards, all right? Someday you're going to have the flu and you're going to want to switch weekends. Great grandma will never manage to come visit on the right weekend to get to see the kids. You're going to have to work with each other some. And the more you do, the less you spend on attorneys, and you can make your life and your kids' lives much more livable.
I agree, 100%.
Child support. Can you explain how child support gets calculated and that it is not a judge was mad at me so he stuck me with child support, it's more than I can afford?
Absolutely. The rule of thumb is that for one child, it's 20% of net. And whenever I meet with people, I spend quite a bit of time making sure that they understand net is not their paycheck. Net is what the state of Texas has decided net's going to be based upon what their gross income is. And you take your finger and you can run it across the chart. Anybody can pull that up, and I encourage the people that I see to pull that up because that's what net is. Also, the idea that, well, I don't get overtime all the time, or, well, this is really commission, all these things, it's still income. And that's the hardest thing, I think, to get folks to understand is that the overtime is income. It comes into the gross calculation, and it will be divided by 12, whatever that number is. But the idea that net is my paycheck, it's not.
One thing the court doesn't want to do is have the children eating caviar at one house and bologna at the other, okay? And so there are circumstances where people come in and say, we've agreed on a week-on, week-off, 50-50 schedule, so that means no child support, right? Well, Dad makes $150,000 a year. Mom makes about $60,000 a year. And there's a really big income differential, and it will affect the children if we don't address that.
Correct. I agree with that. And most courts will address it.
There is even some precedent these days for someone who may have primary conservatorship of the children paying child support to the other person, especially if they're disabled or they have the inability to earn a reasonable income to take care of their house. We talked about coming back to temporary orders. I find that preparing for temporary orders is about the most important time in a case, especially involving kids. Why do you think that's true?
No, I do. Because in most of the courts up here in North Texas, we get one bite of the apple when it comes to trying to get some orders in place to hold the peace until we can either get to mediation, get some discovery done, or get ourselves to trial. It's very difficult in a lot of the courts to go back in to try to modify something. Most of our courts up here in the North Texas area, they limit each lawyer on their amount of time that they get to present their case. I think it's incredibly important that the lawyer sits down and actually talks to the client before they get to the courthouse about what their testimony is going to be. Almost all the counties up in this area in North Texas have what are called, I guess, required documents before you get in to court. Having those filled out correctly, having them ready to go, and having what's called a request for relief, so the judge knows exactly what you're wanting from the outset of the case, so that it's like a roadmap. I think it's incredibly important that those documents are done correctly, gone over with the client. They know exactly what your first 5 minutes are going to be used. It's going through those documents and through that request for relief to get the important issues out. And I think it's probably one of the most important hearings most of the clients actually have, because sometimes it ends up being the only hearing.
Correct. Yeah. Well, and sometimes clients are a bit resistant to turning over the documents. Why do they get to see my paycheck? So that we can get through that area. And what I find is that when you and I come in, we've got our documents prepared, and first dash out of the gate, we hand them to the judge, introduce them into evidence. We've covered that issue. We know what everybody makes. We know where they work. We know what their work hours are. We know the names and ages of the children. We know if everyone's insured. We've handed that all to the judge, and then that frees us up with the time to be able to explain to the judge your position on what are the important issues in your case. If, for example, someone has a drug problem or a bad drinking problem, we'd like to be able to get to that issue for you, but we've got to cover the required elements first to do so. And so if you are quick about putting together your required documents and getting them to your attorney, you free the attorney up to do their job, and you spend a lot less money. If we're just having to pull the documents out of folks, it makes it really, really hard. Okay?
I agree. The times that I have sat in court waiting my turn, and I hear someone's client in another hearing, not mine, say, in response to the lawyer, I want full custody.
Oh, yeah.
No, you don't. You really don't. And you can tell that lawyer has spent zero amount of time educating their client on what type of conservatorship Texas has. And I think it's a true disservice to clients when they truly believe, because the internet said it, the guy at the bar said it, or margaritas said it, that they're going to get full custody. Because there is no such thing, and I think it's a true disservice when you sit over here in court and hear that, because you can tell zero time was spent with that person.
A lot of other states still rely on sole custody rulings more than we do here in Texas, and I think that may be why folks are seeing that on the internet, or they're seeing it in decrees from other states. But in Texas, in the absence of a history and pattern of family violence, the court is required to use joint conservatorship. Now that doesn't change child support, it doesn't change visitation, it just says both parents can be trusted to make some decisions about what's best for the child.
Correct, and the judge is still going to determine which rights to give to which parents. It's no more than a label, but the label of full custody, that ain't in Texas.
That's right. And you raise an issue there that I think is really important and people don't understand. And that is, there's a whole bevy of issues, parenting issues, that the court will decide whether one party or the other is going to have the final right to make the decision after meaningful consultation with the other parent, so that they don't have to come to court when they disagree.
I agree with you on that. And, for a long time, here we go, way back when in the old days, we didn't always make education an exclusive.
Mm-hmm.
And there was a time, and it was the era for that, to where the parents could both make educational decisions. But when it got silly, where one was enrolling in school A and one enrolled in school B, and they kept rolling and unenrolling, now I think that having exclusives on some of these is probably what's needed. I think it's a shame. I think that both parents should be able to make those decisions. But when you have, two parents that just can't possibly do that, then it has to be. But there was a time when we didn't have all that. But
I don't think we had that many options. Today you've got homeschooling and charter schools, and it used to be, when I was growing up anyway, that which school you attended was pretty well dictated by the house you were living in.
Sure, absolutely, but not anymore.
No, so
not anymore at all. We've had to be very creative in parenting plans, especially with homeschooling. Which charter are they going to follow, and how often are they going to have the outside curriculars? And it's been a big boom in Texas on that. We are behind on that, I believe, in the legislature a little bit on homeschooling for that, but we'll catch up.
Yeah, the legislature, the Bar Association has some legislative committees working with the legislature, trying to help them draft new rules, and it's a challenge. While many members of the legislature, easy for me to say, are indeed attorneys, they may not have practiced in this field. And it's really hard to write a law and anticipate how that's going to be misinterpreted in the future.
Well, that's true. So, yeah, every word has a meaning, every action has a consequence. Well, every time they tweak with a rule, there's a consequence, and each trying to figure out what that could be is a challenge.
Who would have thunk it that these facts could come up? Another thing that we see, and I know we're running short on time here, is a lot of folks have the wrong idea about their retirement accounts.
They sure do. They sure do. And and I tell people all the time, this is a community property state, and I know you earned it, and I get that, but she earned it too if it was earned during the marriage. That's pretty much the same idea when people say, but I made all the house payments, and you may have, and I'm not arguing.
With our money.
Yeah. That's the key. And we're a community property state. So the basic premise when you walk into the courtroom is anything that was earned during the marriage or that you gathered during the marriage is community property. Are there exceptions? Of course. If you inherited it, it was a gift, far and few between these days, far and few between in the era that we live in. Most everything ends up being categorized as community property. And it's subject to a 50-50 division before the judge hears the facts of the case. Then it can go either way.
Again, that's another presumption. The presumption is that 50-50 is fair. But there are always other facts that can have the court look at it and say we need a more balanced approach towards this thing.
Correct.
This is one of the reasons why alimony is so scarce in Texas, because under the community property rules, you each own half of it already. Okay, so and no one's going to have, in 99.99% of the cases, an obligation to continue support of the other spouse after the divorce. Child support's a different story. Disabled adult children can be a factor that is an issue. And of course, grandparents want to get in and see the babies and that sort of thing. We're still struggling with grandparents' rights in Texas.
I agree with you. Everything came down out of Colorado with Troxel, and since then, I don't really think anybody can get a handle on it, because does everybody think grandpa and grandma should see the grandkids? Of course they do. Do they actually have a right to interfere with what mom and dad think should happen with their own children? No, they don't. And that's the fine line. And it's a really troubling area. I see why we all struggle with it, whether it's Texas or Massachusetts or California, wherever it is, we all struggle with it. Because should grandpa and grandma be involved? Absolutely. But you can't start trumping over mom and dad.
That's right. And like you said, all the states are dealing with some of these thorny issues and trying to figure out how to do it. You raised a really interesting definition just then, which we're seeing today all the time. If you follow the Supreme Court, it seems like a really large number of their decisions of late are coming down on the issue of standing, which is, do you have the right to ask the court to give you relief? Okay, and we have certain minimum thresholds that people have to have before they can jump up. For example, there's a lady with a stroller walking down the street. I don't know who she is. I don't know who that child is. But I have no right to go to court and say, I'd like visitation with either one of them. Okay? And that's a simple example, but standing is a really critical issue in these cases. Let's see. I think I'd like us to talk just a little bit before we have to close out here about the children's rights and their right to be with each other, with both parents. Can you speak a little bit about how, as a family law attorney, we can assist the children in enjoying the rights they should have?
And I do. I think that children should have the basic right to be able to see their siblings. It doesn't always happen. Do I think that that's wrong? Sure, I do. But there are situations in which it just can't happen. I think that each child should get to see mom and dad. I think each child should be entitled to have a healthy relationship with mom and dad. I think that in a perfect world, which unfortunately we don't have, children would be able to be an active part in what actually gets said in the courtroom, which is why on rare occasions we have what are called ad litems or amicuses that can actually speak for the children. And in some situations, those are really, really good things because the children need to be heard. But overall, if each parent could be healthy for their child, that would be the best of all worlds, because then they would be the ones that would actually giving their children the rights that they're entitled to since they made them and got them here.
I would tell folks that none of us know everything about everything, okay? When you are dealing with a family law case or dispute, you are dealing with what is probably the most precious thing to you in your life. And you really need to seek the best advice you can get. At Bailey & Gallion, we don't charge anything for the first interview. Teresa and I will sit down and meet with you and go over the facts of your case and what your circumstances are. And we will meet with you for free at any one of our offices or on the phone or by Zoom or however we need to accomplish that. Because we really want you to have the information you need to make smart decisions, okay, about your life and your children. At Bailey & Gallion, we always offer free consultations for attorneys so that you can make the most of what you're trying to accomplish and not harm your children. So if you have an issue, please give us a call or come by and see us. Again, today we're at the Legal Cafe, serving up solutions to your legal problems. And we have attorneys here and coffees and a barista and sandwiches and everything to make you comfortable to come in and have a visit. Where are you officing right now, Teresa?
No, my office is actually in the Dallas office, and we're off of Stemmons Freeway, which most people know as I-35, and Inwood, and that's where I am the majority of the time. I am as Keith said in the beginning, the managing attorney for the department. So I'm in all 10 offices throughout the month. So I'm not always where I'm supposed to be, but you can always get me by myself.
And I'm usually around in either Tarrant County or Parker County, but we'll make an appointment to meet with you. Again, thanks for joining us today, and call us if you have any items that we can assist you with. Have a good evening.